Senate Democrats have announced that they will propose new legislation later this week to rein in the rogue Supreme Court. Intrigued? Then click that like, subscribe, and the alert bell, and enjoy the video. So if you've been paying attention to my channel or any other political commentator's channel, you've no doubt been aware that the Supreme Court has become a recurring theme for progressive political commentators. And that's, of course, because there are many, many problems with the current iteration of the Supreme Court. And actually, if we're being quite candid, there have been issues with the Supreme Court for decades, and arguably since the inception of the country, because, of course, nothing about any system of government, including ours, is perfect. One of the many recurring complaints about the Supreme Court is that there's little oversight to it. As we discussed in a previous video, the notion of separation of powers and checks and balances are also supposed to apply to the Supreme Court. We see where Congress and the president can check one another. You know, the president can veto legislation by Congress, but Congress can override the president's veto, et cetera, and so forth. And under the current system, the practical limitations mean that the president and Congress are basically powerless to check the Supreme Court without doing things that many people consider to be norm violations, right? Now, the president could theoretically not comply with a judicial decision that would be seen as norm breaking by many people. Congress could theoretically pass a constitutional amendment to, to modify the Constitution, which is beyond the scope of what the Supreme Court can review. So if the Supreme Court strikes down a law as unconstitutional, Congress could theoretically make that law a constitutional amendment, and the Supreme Court can't do anything about it. But of course, you need 2/3 majority in both chambers of Congress, and then 3/4 of the states have to ratify it. So it's virtually impossible. And because of this, you have 9 unelected judges who serve lifetime appointments. They don't have to run for re-election. They're there until they die or choose to retire. And that gives them a lot of latitude, a lot of freedom from accountability, which of course is an environment which breeds corruption. And as we've done videos in the past several months, we know that conservative justices Thomas and Alito have been credibly accused of corruption by failing to disclose hundreds of thousands of dollars of lavish gifts and favors that come from partisan conservative figures, right? Of course, that's an act of corruption. And the Supreme Court basically has decided that it can't be checked, right? And that if they choose to behave a certain way, well, that's their choice, but nobody can impose a code of conduct on them. And this is an article from back in February, and it's relevant to what we're about to talk about because apparently, the Supreme Court is well aware of the fact that they're under scrutiny, that a lot of people are unhappy with them. As a matter of fact, American approval of the Supreme Court is at its lowest in recorded history. More Americans disapprove and distrust of the Supreme Court than they do Congress or the president. That's how unpopular this branch is. And you can tell that the justices are feeling the pinch. So apparently they have been internally debating, okay, well, maybe we should adopt a code of conduct for ourselves. We don't believe that it can be imposed on us by other branches, but we'll adopt one for ourselves. Except apparently after consistent debate, they've been unable to come to a consensus about a code of conduct. So there is no code of conduct for them. And with that in mind, Senate Democrats have proposed legislation that will impose a code of conduct on the Supreme Court. Basically like, hey, we have legitimate questions about your commitment to ethics and ethical behavior. You've been given ample time, decades really, to impose a binding code of conduct on yourselves. You've not done that. You've failed. You not only have failed to do that, but there's credible evidence that you have flagrantly violated the codes of conduct that do exist that you claim to consult, but clearly don't. So since there's a problem, and there's been a problem for decades, and you don't seem to be in a hurry to fix the problem, well, then we'll fix it for you. So the chairman of the Senate Judiciary Committee, a Democrat named Dick Durbin, and Senator Sheldon Whitehouse, who's one of my favorites, also a Democrat, has proposed a new piece of legislation to be unveiled later this week. And the bill would require Supreme Court justices to adopt a code of conduct, create a mechanism to investigate alleged violations of the code of conduct and other laws, improve disclosure and transparency when a justice has a connection to a party or amicus before the court, and require justices to explain their recusal decisions to the public. Folks, this is huge. Now, we'll get into, again, the practical considerations of this piece of legislation, right? But I'm going to go back to some notes that I made and I brought up in a previous video. I made these notes over the weekend. They're kind of a compilation over the history of Supreme Court reform, the fact that it is and always has been a political body, the fact that it's been changed multiple times throughout its 230-year-plus history, often for political reasons, and often by presidents that we consider to be great, for example, like President Lincoln, but also to address the specific means by which court reform could be sought. And one of the sections of my notes is, members of the Supreme Court or the current court are hella corrupt, and there's little means to redress that corruption. And it's true. So, there's a federal statute which supposedly applies to not just federal judges, but also Supreme Court justices, demanding that they recuse themselves in any proceeding in which his or her impartiality might be reasonably questioned. In that case, it's not even that your impartiality is compromised. It's if a reasonable person can believe that your impartiality is compromised. Just to avoid the evidence of impropriety or the appearance of impropriety, you're supposed to recuse yourself. But there's no enforcement mechanism for that, right? So if a federal judge doesn't abide by the statute, that decision can be appealed to a higher federal judge, right? So if you're before a federal judge, if you think they should recuse themselves, that federal judge chooses not to do it, you can appeal that decision, and then a higher federal judge can review that decision and perhaps make a contravening decision. Nobody can do that with the Supreme Court because the Supreme Court's the highest federal judiciary body. See the problem? So there's also the fact that recusal decisions as they currently are, they don't have to be elaborated on. So if a justice recuses themselves, they're not obligated to explain why they're recusing themselves. They're not obligated to explain why. And if calls are made for them to recuse themselves and they choose not to, they don't have to explain that either. They can just simply say, no, I'm not going to do it. Or they don't even have to say that. They just don't do it, right? So obviously one of the big examples is a recent, just earth-shattering example of non-recusal when there should have been a recusal, is the corrupt conservative Justice Clarence Thomas, whose wife, Ginny Thomas, is a conservative activist who was sending text messages to Donald Trump's chief of staff and others, encouraging them to propagate the big lie that the 2020 election was stolen, and even, helped instigate the insurrection by encouraging insurrectionist behavior. Well, there was a Supreme Court case concerning that scheme by Trump allies to try to steal the 2020 election from then President-elect Biden. And Ginny Thomas, the wife of this conservative Supreme Court justice, was materially involved with that case. He should have recused himself. He should have been like, hey, my wife's involved. I got to get out of this. But he didn't. Not only did he not recuse himself, he stayed on. And he was the only vote in favor of his wife and her allies, the Trump allies who were trying to steal the election from President Biden. That's an incredible act of corruption. This is disgusting. That should not be tolerated. And there's also the fact that there is no code of conduct, as I said. There is a federal code of conduct that applies to other judges and is enforced to other judges. And though the Supreme Court says they consult that particular code of conduct, it's completely voluntary, right? So the fact of the matter is, this is not a good system. There has to be oversight. The President of the United States, the most powerful man in the world, has oversight from Congress. Congress, the Department of Justice can investigate Congress, like they're checks, right? Law enforcement under the executive branch can investigate illegal behavior from Congress. Congress has oversight powers over the executive branch, including even the president. Why is the court above all this? That's not okay. That's not acceptable. The court is not more of a branch than the other two. If anything, because they're unelected and because they serve lifetime appointments, there should be even more scrutiny of them, right? Because it's like, we can't vote you out. Right? So you should have and because you're a judge, you're not supposed to be a politician, right? You're supposed to be above politics. So if you're a judge, you should basically have to be like a monk, right? Yeah, you should be financially taken care of, like compensated that way. But politicians should be able to behave in ways that you shouldn't. Like there should be like even less tolerance for a Supreme Court justice, conservative or liberal, than any politician, Democrat or Republican. And yet it's the exact opposite. So this piece of legislation, and the Sheldon Whitehouse's website goes into detail, it proposes to create a code of conduct and develop a process for enforcement, improve hospitality and financial disclosures, strengthen recusal requirements, including that they have to provide an explanation for their decisions to recuse or to not recuse, and it goes into details. Now, of course, the other problem is this. Will it pass? Well, probably not, right? So in the past, there have been some bipartisan interests in strengthening some of these. Lindsey Graham, Blanche Devereaux from Golden Girls, I do declare, even he has expressed interest in the past of, ethical reform for the Supreme Court. But, as is often the case with Lindsey Graham and Republicans, now Republicans are slow walking it and speaking out against it because they see it, or they claim to see it, as ethics reform is simply a means for Democrats to punish the Supreme Court for deciding cases in ways they don't like. So even though they say in principle, hey, we support strengthening ethics, rules for the Supreme Court, we're not going to back your legislation or do things bipartisanly to help you because you're just trying to stick it to the Supreme Court. So, obviously this legislation hasn't been proposed yet, so I may be surprised, but I doubt that you're going to see much, if any, Republican support for it, even though in another world, you probably get quite a bit of it. And that's just with one chamber. That's the Senate. Now, theoretically, if the entire Democratic caucus, so that includes, Kyrsten Sinema, Joe Manchin, Bernie Sanders, Angus King, the independents or who caucus with the Democrats, theoretically, if they got it and they wanted to break the filibuster, to just do based on 50, 51, 52 votes, they could do it. But then you have to get it through the House of Representatives, which is controlled by Republicans. Could you get enough Republicans from the House of Representatives to back this legislation? So it's a tall order. It's unlikely to pass. But this is a step in the right direction, right? This is arguably the bare minimum, long overdue. We'll see where we go with it. But I think Democrats are going to have to win both houses back in 2024 for this legislation really to go anywhere.